Good evening. This is John Milburn for Laws 11046, Law and the Environment. This is week 3 in 2017. We have a couple of people online. If you're looking at this recording after the event, please consider joining us for the live session. I'd certainly appreciate it. The idea of the live sessions, as much as anything else, is to engage in a discussion and go through some of the weekly problems. If we can't get people on the live sessions, I'm always happy to talk about the live or the weekly problems in the Moodle discussion area, but I'd prefer if we had a chat in the session. The other thing is that you would have noticed that this week I uploaded some notes that I prepared a few years ago now in relation to the weekly chapters in Bates' 8th edition of the text. I've supplemented that with a comparison guide so you can see the weekly chapters, the chapters in the 8th edition and compare those to the chapters in the 9th edition. If you listen to those recordings, it will bear you, it'll do you well for both the 8th and the 9th edition. And at some stage, when I can, I'll do the same process for the 9th edition. So treat that, if you like, as the formal lecture, and the sessions that we do interactively Zoom, I guess more a tutorial, but there will be a lecture component in it. By now, you should have commenced your work in terms of the first assessment. If you haven't, please start to do that now. Have a look at my sample document, which I've called an assessment guide, to give you some idea of the layout and the format. Have your headings set out now for how you wish to attack the assessment, and start to fill in the detail as you progress through your reading or you hear something on a recorded session like this. It's very important that you work backwards, and that means start now. Have your plan structured for that first assessment. Have the skeleton ready so you can fill in the detail progressively. Don't leave it until the last minute. Anyway, enough of that lecture. You've joined us in environmental law probably at just the wrong time, I hate to say. And the reason for that is that while the Commonwealth legislation is stable and current, that's not the case in relation to Queensland legislation, at least insofar as the planning component of environmental law is concerned. So tonight, I want to talk about the overall structure of decision-making in environmental law that necessitates a discussion about planning law, and the two are very closely aligned. Talk about the separation of powers. Consider the common law aspects, which is chapter 3 of the text and really the reading for week 3. And then have a look at how that works in practice in the context of the law as it is now and the law as it will be in July this year in Queensland. So we have two pieces of current legislation, one in effect, the other dormant but ready to go. So we'll talk more about that later. Before I do, we've got just a couple of participants. Jace, John, do you have any questions or comments at this stage? All good?
Oh, I think it's really good. Thanks, John, for giving us all this extra information. Yeah. I also think it's really bad that you're giving us extra information.
I know. And I must confess that I do run the risk of overloading you with information. And there are some things that you can let go if you find that there's just too much. And what I might do is go through the Moodle site and identify some of those things that if you're really running out of time, you can let them go. So, but I would listen to the discussion that I have in relation to the 8th edition of the textbook, which is that earlier edition of Bates, and they're those weekly lectures. I'll do the same thing for the 9th edition when I have a little bit more time. Okay, so the first thing that I want to talk about is the separation of powers. We talked about that last week. So we know that Parliament has a role to play, the Executive has a role to play, and the courts have a role to play. I trust that you're on top of that now, and if you had an examination question about the separation of powers and how it works in relation to environmental law, both at a state and federal level, you'd be able to nail that question. If I were you, I'd have some notes prepared in relation to that question. Okay, so we've got the separation of powers. We have the Parliament that makes the laws, the legislation. We have the executive that looks after implementing that law, and we have the judiciary that deals with disputes in relation to it. All of that at both a Commonwealth level and a state level. So you need to understand the difference between those three branches, and you need to understand the difference and layering of Commonwealth and state. If you don't, ask a question, preferably on UCRU, and we can talk about that. So I'm going to assume that we're on top of that and you know all about the doctrine of separation of powers. Oh, Suzanne has joined us. Hi, Suzanne. I'm pleased that you found us. So if you do have a problem with the separation of powers, please let me know. I'm also going to assume, following our discussion last week, that you understand the concept of the Crown. That's all right. I've muted it for you. All good? Welcome along, Suzanne. How you doing? Can you hear me okay? Can you hear us there, Suzanne? I'm not sure if Suzanne can hear us. Or see it, perhaps. Give us a thumbs up if everything's okay there, Suzanne. All good? All right. While Suzanne's working out some technical issues, I'll continue. So you need to understand the concept of the Crown. You need to understand how that works in environmental law. And again, if I were you, I'd just pay some attention to the Mabo decision, the Wick decision, and the native title legislation from 1993, which of course is the native title legislation. This will just test your statutory abilities, Commonwealth or state, the Native Title Act.
Commonwealth.
Thank you, John. Excellent. Commonwealth. Jace is agreeing with that. And we're not sure if Suzanne has been able to hear us yet, but we'll continue. And hopefully Suzanne will go to the chat facility or unmute her microphone if she's got any problems. All good, Suzanne? No, we're not sure yet. Okay, I'll keep going. So if you have any problem with that, let me know. One thing that you will find that's, I think, is very interesting is this whole concept of overcoming private property rights and compensating people in relation to environmental laws. Now, that's really the heart of environmental law. I'll just explain that in more context. You see, when I started to study in the 70s, as I mentioned last week, we didn't have environmental law. It wasn't really on the radar at all. So people with an environmental law issue had to consider laws such as contract or torts or something else that might give them a remedy. But in many cases, the issue to do with the environment affects the wider community, not just the neighbour of the property upon which someone has commenced an illegal, coal mine, if you know what I mean. So there's wider consequences. Now, if someone is lawfully going about their business and in the course of doing so, they cause environmental harm, the question is, to what degree and how do we stop that? And to what degree and how do we compensate the landowner who is otherwise doing something quite lawfully, which is now deemed to be against the public benefit because it breaches environmental laws? So again, if you're preparing for the end of year assessment, I would really have a close look at how you doing? I'm not sure if Suzanne has joined us yet. Got some problems over there. Looks like John has gone to help her, Jace. No, we're not. We're not getting Suzanne. I'll just see if she'll respond to a chat. Hi, Suzanne. How are you going? Can you hear us? That's my voice recognition. All right. Well, we'll see if Suzanne responds to that. Otherwise, I'll keep going. So do have a good look at that issue of compensation. I'm really interested to know from a theoretical perspective. Okay. Just bear with us. Suzanne can't hear anything. Suzanne, the other participants can hear me, so I think there may be a problem at your end. Now, all right, well, I'll continue and hopefully we'll respond to Suzanne's issues. We'll see if she can work on some headphones or something. All right, so do have a look at that issue of compensation for people when their rights are taken from them. You've seen The Castle, Jace? You've seen The Castle? John, you've seen The Castle? Everybody's seen The Castle.
Of course.
And of course, it's a great movie. It's my favourite Australian movie. So just think about that concept, but within the context of environmental law. Somebody's doing something perfectly lawfully. Environmental law says, now you can't do that. To what degree can they be compensated? And it works two ways. The first is that they might actually, the government may, through an executive decision, come in and actually take something. That's one thing. And the other is that the government, through an executive decision, might deprive someone of something. And by depriving them of something, the question then becomes, is that person entitled to compensation because they were otherwise relying upon that thing which is now deprived to them or of them? So I hope that makes sense. And you need to understand that and be ready for it, because that might be in the take-home exam as well. Okay, so lots of hints tonight in terms of what we want you to do. So just remember the basic rule that the acquisition of property does not include a mere restriction on property rights in general terms. Think about the social context of environmental laws. Now, chapter 3 of the text deals with the issue of common law, and common law is what? John or Jace? I have to pick on you because you're the only ones that are here and the only ones can hear me. So what's common law? Yes, John?
Judge-made or case law.
Spot on. That's great. Okay. So, Jace, I have to pick on you now. If there is a difference, a clear conflict between common law and statute law, which one prevails? Statute law made by Parliament. Common law.
I really want to say common law has the final say.
John, what do you say?
Because
I'll pick one, it's statute law.
John goes with statute law, Jace goes with common law. Look, to a degree, you're both right, and I'll explain that. The general rule, the general proposition is that where there's a conflict, the statute law prevails. That's the general rule. But there is a bit of an exception to that, and the exception is when we're dealing with High Court decisions. So in the context of environmental law, you would have seen many decisions in the 80s which relate to essentially the states attacking the Commonwealth in relation to its environmental law making. So the Commonwealth was, in the 80s, was starting to gear up with environmental law legislation. And as we discussed last week, and Suzanne's can hear us. That's great. All right. So Suzanne's another person who can answer questions as we go. Thank you for joining us. Suzanne, just out of interest, how did you know to join us on this site? Did you see the email or on Moodle? I'm just going to test your microphone, you see. I'll just unmute you.
I didn't get an email, by the way, John. I tried to get through email and I didn't get one.
Didn't get it. All right. I'm not sure. This is on the landing.
I saw it on Moodle.
Oh, good. Okay. All right. Well, I tried to get that. What happened, Suzanne, is that we had a clash of times for licenses. So I had to review my own Zoom license. Okay. So we were talking about the issue of compensation. We were talking about what prevails, state law or statute law or common law. And Jay said, well, in some circumstances, common law can prevail. And I've said, yeah, in the context of a High Court decision, the High Court can overrule Commonwealth legislation. And we saw a spate of that in the 80s. Have a look out for the Tasmanian Dam case. It's a seminal decision in relation to legislation passed by the Commonwealth in relation to environmental laws issues in Tasmania at the time. It was really big news back in the 80s. And the states attacked that legislation on the basis that Commonwealth didn't have power to make environmental laws. So those laws were invalid. They were beyond the power of the Commonwealth, and the High Court disagreed, as they did in a series of cases until eventually, in a way, and I have to be guarded by this, but in a way, the states kind of gave up on challenging the Commonwealth in making these environmental law issues. Instead of attacking the Commonwealth through the High Court and losing, how did the states respond? And I'll give you a hint, they became more cooperative. Yeah.
I was going to say that they made their own planning laws and...
Well, yeah, they do. And the states do make planning laws. And of course, in Queensland, we're going through that transition that I alluded to at the start of tonight's session. But what happened is that we have have a look at COAG, C-O-A-G. Do a little bit of research about that. And that will lead you into some interesting discussions about the way in which international treaties have been implemented at a Commonwealth level with the states cooperating. It'll also give you some guidance as to things that we'll talk about later in the course, which relate to bilateral agreements and the way in which, particularly in environmental impact assessment, the Commonwealth and the states work together. So COAG, have a look out for COAG. Okay, so that was kind of the response to what happened in the 80s. In the early 90s, we started this more cooperative approach. Okay, so what we've identified is that for the most part, generally speaking, where we have a clash of a statute and the information or decision of a common law, then the statute will prevail. But the common law is still important for a number of reasons. Common law, which is judge-made law, as John told us, relates to decisions that are in relation to facts that are in dispute. Look, when it comes to statute law, we have layers. We have Commonwealth and we have state, we know that. But let's say at a state level, it's not just a case of we have one layer of statutes. Even the process of providing for statutes is layered in the sense that we have acts of parliament, we have regulations, we have rules, we have so on. And then we have, delegated legislation where the state parliament delegates to the local authorities power to make certain decisions, to save time, to cater for changed circumstances and a whole range of things. So when we talk about statute law, we're really talking about a range of things which include, and primarily, but include acts of parliament. So don't forget the importance of, say, regulations when it comes to determining what Parliament says is the law. And how are you accessing legislation? So if I said to you, look, go and have a look at Section 8 of the Sustainable Planning Act, just out of interest, how are you doing that? Suzanne? Can I pick on you for a sec? I really want you to tip your micro. Yeah.
I haven't tried as yet to access the acts.
Okay. Yep. All right. So we want to change that. So we'll give you this as an exercise to do. Jace, how do you access legislation? So I said go and have a look at Section 8 of the Sustainable Planning Act. No, I'll just unmute you there, Jace.
Yep. Generally, I would just find it online and do what I can to find it that way.
Oh, okay.
And then,
use Google, Dr. Google.
yeah. Honestly, yeah.
So you put in Section 8 Sustainable Planning Act. That'll get you there. That'll get you there. John, what do you do?
Similarly, either that way or just look it up and do it online.
Yeah, sure. I agree with the online. Look, I'll show you a really easy way of doing that tonight when I briefly compare the Sustainable Planning Act and the Planning Act, which are the two pieces of legislation that I've been alluding to at a state level. To be honest, even though it's not authorised, I use AUSTLI, AUSTLII.
I've done that for the assignment. I looked at AUSTLI.
Yep. And for the most part, it works fine. It doesn't always work. For example, I was recently appointed a member of the Mental Health Review Tribunal, and we're now working on the Mental Health Act 2016. You'll find that in the authorised section of the Office of Parliamentary Counsel, but you won't find it on unauthorised AUSTLI just yet. So sometimes there is a lag, but AUSTLI is really convenient. The authorised site is under review, and soon I think it'll be every bit as good as and easy to use as AUSTLI. Anyway, we'll show you that shortly. Okay, so we know that if we have a conflict between a statute and a case, then we generally go with the statute. But the courts are there, the common law is there to deal with issues that just weren't necessarily considered when Parliament made the legislation. If Parliament had to make a law that covered every single factual circumstance, we'd never, ever finish writing legislation. It's just not possible to do that. Just an off-topic example. If the law said you can't drive carelessly, then what happens if someone is changing channels on a radio station? Do we still do that? Do we change channels on a radio station? While they're driving a car and they have a car accident. Is that careless driving?
Sure is.
Is it? Okay, I don't know. That might be in one of the regulations. So...
And I've done it.
Have you been pinged for it?
No, but I've done it. And I've actually nearly had an accident on the highway doing it. And
to be honest, I didn't realise that you weren't allowed to change radio stations while you're driving in a car.
You're driving along and you're listening to the stereo and you need to change your disc or you need to change a station. It's really easy it's just like a phone.
Yeah, I don't know about changing discs, but unless it's all electronic. But anyway, I guess the point is, what I'm trying to say is that if you had to cover every single circumstance as to what something means, the books would be huge. So courts are there to deal with the particular circumstances between particular people at a particular time. And as a result of that decision, they may in fact create some law. The decision of a high court in relation to an environmental law matter then becomes binding on state Supreme Courts, planning and environment courts, local councils, etc. So it filters down, doesn't it? Okay, so we call that, the doctrine of precedent. So if there has been an earlier case and the court, with some authority, decided things in a certain way based on a legal principle, then that then becomes binding on later judges faced with the same legal principle. I hope that makes sense. Yes, John?
So if you disagree with that, then you have to take it to the higher court.
Yes, that's one way of doing it, and that's the immediate way of doing it. So if, for example, you're not happy with the decision of the Planning and Environment Court, let's say you've made an application, the application was denied or approved on conditions you weren't happy with. You then, as the developer, go to the Planning and Environment Court, state your case, get an argument, have a decision. You're not happy with the decision of the Planning and Environment Court, which is at the district court level in Queensland. If you're not happy, then yes, you appeal. Out of interest, who do you appeal to?
Supreme Court?
Yes, sort of. The Supreme Court has two divisions. It's got the trial division and it's got the appeal division, which is the Court of Appeal. So it would actually go to the Court of Appeal, but that is part of the Supreme Court. So, yeah. Okay. You need leave, but that's where you would go. The other way in which judge-made law can be overturned in a more general sense, a broader sense, is how? Suzanne, can you help me with that?
Merits review.
Merits review is going to court and asking the court to do a review of the decision. So, yes, if we're not happy with a decision of local council, then we appeal to the Planning and Environment Court, and in the course of making a decision, essentially the Planning and Environment Court will undertake a merits review process, but it's still a decision of the Planning and Environment Court, albeit that they did it as a merits review. I hope that makes sense. So it's not really the answer I'm looking for. So the question is this: in a broader sense, if someone, let's say politicians, are not happy with the way in which the courts dealt with a certain matter in a case, how can they, the politicians, do something about it?
They can change the law.
Exactly. Thank you, Suzanne. Thank you, John. They can change the law. So if the Planning and Environment Court makes a decision which becomes part of our common law, and there's a public outcry, we can't have this, blah, 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 or the politicians just decide that it's no good, then because statute law trumps common law, just pass an act. And then that common law that was made by the judge is no longer part of our law. We look to the statute as well, or instead. See, when I first started studying law, which is back in the 70s, and I've pretty much practiced law every day since then, one way or the other, much of our law was common law. And if you look back 20 or 30 years before that, much more of it was common law again. Statute law is increasing in terms of number and its reach. So now we look much more to the statute law than the common law, and that's really reflected in Bates's book. Okay. All right, so what we've been talking about so far is the common law. We know it's judge-made law. We know that it has its place, and we know that it can be overtaken or superseded by legislation. We also know that common law is created at both a federal level and a state level. So at a state level, the important courts are the Planning and Environment Court, which, as Suzanne mentioned, does its work primarily by way of merits appeals. We have the Queensland Court of Appeal, which is the appeal court from the P&E Court. And we also have the Land Court, which is Queensland-based as well. So they're the three courts that I would be urging you to consider and have a look at. Why not go on their sites and just poke around? Just go and have a look around and get some idea of what these courts are all about, just in a general sense. So when we talk about common law in Queensland, that common law is primarily made through decisions of those courts. So the notes that I've prepared for you for week by week really emphasise decisions of those courts, don't they? So you would have noticed in your reading of the weekly notes a lot of reference to decisions of the Planning and Environment Court, to the Court of Appeal, and to a lesser degree the Land Court. So that's where I want you to concentrate your efforts for common law in Queensland. What are the courts in the federal sphere that might have some relevance in common law making federally?
The Federal Court.
Federal Court, yes. What other court? What's that, sorry? The High Court, yes, exactly. All right. So the High Court is a federal court. It's, of course, the highest court we've got. There was a time when it wasn't, but it is the highest court we've got. And it takes appeals from the federal court in relation to federal issues. And in relation to state issues, potentially it can take appeals from the Court of Appeal. Does that make sense? We wouldn't see that very often, but potentially it could. So the High Court is really there to deal with those major issues like constitutional issues in the context of environmental law. Okay, and I think it was before you joined us, Suzanne, or at least before you could hear us, I mentioned in the context of Commonwealth law, have a look at the Tasmanian Dam case, really important from the 80s. Okay, and I gave you a hint before to say, all right, if someone loses their property, their land, their entitlements, their licensing, their opportunity to run or continue running a business, then how do they get compensated, and in what circumstances do they get compensated? Do they get compensated because they've lost property? Do they get compensated if they've lost permits? Do they get compensated if they've lost licenses? And many of those answers are found, at least originally, in the context of the common law. So common law actions were often based on people claiming a loss because of what somebody else did, and that then flows on in other ways through the statutes as well. When you're dealing with the common law, also look at that section of the text which deals with the defence of statutory authority, which is where decisions were made and actions taken in good faith in pursuit of statutory functions. So that might be an interesting area to consider for your end of year examination as well.
How do you prove good faith?
That's a really good question. That's a really good question, because I guess sometimes you somewhat cynically think that decisions are made in circumstances where it's not necessarily motivated by good faith, but by economic issues as well. So I'm not sure I can answer that with a single sentence, but have a look at the case law. For example, have a look at Von Son and Forestry Commission of New South Wales. That's a good case to give you some guidance as to what we mean in terms of this whole issue of statutory authority. Okay. All right. They're probably the main things that I want you to consider from the reading for this week. What I want to do now is have a look at some online resources that might assist you in getting a better feel for environmental law. To do that, I need to share the screen. Before I do, any questions, comments? All good? Okay. I'll share the screen now. Let's see if this works. Okay. With any luck, you can see the website for the Department of Infrastructure, Local Government and Planning. Is that it? Yes? Good? All right. So I would urge you to go to this website and again, just have a look around. Get a feel for what's there. Get a feel for what the department does, and have a look at some of the drop-downs, and I'll show you some that I think are worthy of comment. So the department deals with a number of things, including the right to information and local government bulletins. In terms of infrastructure, we have the overall planning, which is relevant to state infrastructures. And we have an area which I've alluded to tonight, which deals with the issue of federal and state cooperation. Remember, I said go and have a look at COAG. I want you to get your head around what that is. This is a good place for you to look at it. So that's the Council of Australian Governments. And just get a feel for the history of COAG, particularly in the context of those environmental law decisions of the High Court in the 80s that I mentioned earlier. In terms of local government, the interesting thing here, I think, is the model local laws. If I take a moment to click on that link, what we see is current model local laws, which provide an easy way for smaller councils in particular to adopt local laws, and you'll see some down the bottom. So they're like templates, if you like, but various councils can adopt those. Now, the really interesting part, I think, of this website is planning. And in planning, there is firstly the issue of planning reform. I'll come back to that. There's legislation, which is really important, and I'll have a look at that now. Under that link for legislation, you'll see that at the moment, the primary piece of legislation in Queensland that has a bearing on planning and therefore has a bearing on environmental law is the Sustainable Planning Act of 2009. But you see over here, in mid-2017, there'll be new planning legislation. That's the Planning Act of 2016, and we'll have a look at that shortly. But in addition to the Sustainable Planning Act, at the moment, we have other pieces of active planning legislation. The reason I'm showing you this is when you come to write an assignment in relation to environmental law, you need to just be on guard for legislation or regulations or rules that may have a bearing on the legal issue. So at the moment in Queensland, Sustainable Planning Act is important, and I'll show you shortly why that's important. But there are other pieces of legislation that are important as well. And there are things like this, the Planning and Environment Court Rules of 2010. I really want you to have a look at that. We'll talk more about those later in the course. But if you're involved in litigation in the Planning and Environment Court, you need to know the statute law, you need to know the case law, and you'd certainly better know the court rules. So please have a look at those things. Okay, so they're the pieces of legislation that are relevant in planning. Plan making, at the moment, under our current system, we have different levels of regional planning. This is as the law is at the moment. We have regional plans, and we have strategic planning generally. That page gives you an overview of the statutory regional planning regime in Queensland as it is now, and you'll see that there are specific regional plans that may be relevant to a matter that you're involved in. Also under planning, we have issues to do with state planning. This is important because it provides the overall structure of planning at the moment. We have the state planning regulatory provisions, the state planning policies, then the regional plans that we looked at a moment ago, and then the Queensland planning provisions. So there are the current types of state planning instruments which relate to our...
excuse me, at least it's all straightforward.
Well, it becomes, I think, it becomes more straightforward, hopefully, once we have our new legislation. But the point I guess I'm making is that you need to be aware of these things if you're going to answer a question in relation to environmental law sensibly. Okay, so that's the plan making as it is at the moment. If you're dealing with environmental law, odds are you are dealing with some sort of development assessment. Generally speaking, people are making an application and it has environmental law impacts. So this website provides you an opportunity to walk through the development application steps, and it's an easy way to get your head around it. I think it's easier to look at this type of website than to go to the source legislation from which this material is drawn. Also, when it comes to planning, you have the development assessment process, and you have the ability to look at different ways in which assessment is undertaken. You also have SARA, the State Assessment Referral Agency, and that's a means by which issues can be fast-tracked through the process. So have a look at the SARA Assessment Manager decisions here, just to get a feel for how this all works in practice. Plan making tools are important as well. Okay. When it comes to planning, they're the main issues. There's some issues to do with dispute resolution for the P&E Court and dispute resolution committees. When it comes to economic development, there are a few interesting parts, and resources might be interesting for you as well to have a look at. All right, are there any questions about any of these things that I've talked about so far?
No, just a reaction like, wow, and I thought I was nearly on top of it.
Oh, I'm sorry, and so much, there is a lot of reading, isn't there? Welcome to law. Law is just great, isn't it? Yeah, I'm not sure how I can make it any easier, but I'm trying to make it as straightforward as I can. Okay, so enough for that one.
This is going to have to be a well-watched video.
Maybe, yeah, maybe. So there are some fact sheets about the new planning system that's coming in, and that new planning system is the Planning Act 2016. It's already enacted, it just isn't in force yet, but it will be in July. So have a look for these flyers, which hopefully will be the easiest way for you to get your head around the difference between the current legislation, which is on the left-hand side of the screen, the Sustainable Planning Act 2009, and the legislation in waiting for effect, which is the Planning Act 2016.
Do we have to know that for the assessment?
You don't have to, because I'm teaching the law as it is now, not as it will be. However, I urge you to have a look. And the reason I've got them up screen by screen is I think that's a good way to do it. So that if you're preparing some work and you include some information from the Sustainable Planning Act, it won't take you long to find a counterpart provision in the Planning Act 2016. Sure, it's not part of our current law, so if you fail to include something from the Planning Act, you're not going to be marked down unless I've asked you that specific question. But if you can throw in something from the Planning Act to supplement your answer, that will get my attention and a smile on my face. And you always want a smile on the face of the examiner, don't you? It also gives you an opportunity to get your head around the new piece of legislation rather than relying simply on the old legislation. And there are some counterparts. For example, Chapter 2 of the current legislation deals with state planning instruments. If we look over here, Chapter 2 deals with planning, and Chapter 2, Part 2 deals with state planning instruments. So you can see some parallels between the two. Here's the good news. Let's pan down to the bottom of the Sustainable Planning Act. The one on the left is the current legislation. We pan down and it goes forever, almost makes 1,000 sections. Pan down the Planning Act 2016, which is the legislation in waiting, and it stops at 325. Thank goodness for that. Okay, both of them have a dictionary at the end. Don't forget the dictionary, because if you're wondering what a particular term or word means, it might be in the dictionary. You need to be aware of the dictionary, and you'll see the reference to a dictionary typically at the start of legislation. So in the current legislation, it's section 6. In the counterpart new legislation, it's also section 6. It's not just the form of the two pieces of legislation that have similarity between each other. Some of the substance is relevant to the applications as well. So Chapter 3 deals with the development assessment process in the new legislation, and that's the counterpart of the IDAS provisions. I'll just skip past it, which is in Chapter 6. Okay? So just get a feel for the difference between those counterpart sections. I'll stop the share now and do my best to come back to you. Okay, well, you've been really patient with me tonight. I know there's been a lot of information. Are there any questions or comments? I guess the only comment that you'll say is that you're right on top of all this now. It's all good. No?
Do the problems each week relate to the assessment? Is that what we're learning?
Oh, look, I have a general philosophy. Those people that put in the hard yards and actually put in a good answer to the assessment to the weekly problems should be rewarded, if possible, at the end of your assessment. Also, those people that listen to these videos, or better still, participate, should be rewarded. So what I mean by that is this. There's no actual marks allocated for attending these sessions. There's no marks allocated for viewing these sessions down the track. There's no marks for participating in UCREW, and there's no marks allocated for answering those weekly problems.
A bugger.
But if you do answer the weekly problems, you'll be rewarded in the sense that you'll be better prepared for the take-home exam. In other words, as another hint, if you write those weekly problems, you might find that the task at the end of the semester is so much easier because you've done some of the work already.
Yeah, I agree. My question on UCREW earlier in the week was, will you be providing an ideal answer for some of those problems?
Yeah. And of course, as luck would have it, as part of a clean-up and a change of systems from one to the other late last year, I, of course, deleted everything that I had from my... I've been taking this subject for about 4 years, and I deleted everything. So I will rework my model answers and I'll put that on UCREW, but it has put me behind a little bit, I must say. All right.
Thank you.
Thanks, John. All right. Well, I'd better prepare for another session that I'm starting at 7 o'clock. Just to let you know, I'll try to resolve this issue regarding the clash of timetabling on the Zoom sessions, and let people know what the more permanent link will be. It might be this one. I might just stay with this link that you've found me on. Hopefully we haven't got too many people that are complaining they couldn't find us tonight, but I'll let you know. The other thing is that I'll look at updating chapter 9th edition week by week, but for the moment, watch the lectures and listen to the lectures in relation to chapter 8. It'll be readily transferable. When I'm saying chapter 8, I mean 8th edition, of course. Okay, all good? All right.
You've given me a lot of work.
Yeah, sorry, John, but learning is fun, isn't it? Learning is fun.
Actually, once I got past sort of chapter 2, I wasn't minding reading the textbook. I was actually, okay, this is okay. I can read this.
Yeah, and when you read a case, try to think of it in terms of the wider issues. I mean, there's some interesting things that I've put on the website that I've collected over the years from different offerings of this and other courses. One is, I think I probably put on one from Roger Curry, who was an environmental activist. If I haven't, then I can provide you with that link. And it's really interesting to look at and listen to someone who's actually involved as one of the litigants in these cases, and get a feel for what it was like in the battle itself, if you know what I mean. So when you're doing this reading, think of the people that are involved, the lawyers, the participants, you know, and what led to these situations with cases going as far as they did.
The one thing I haven't really actually got into was the hour and a half video from Mr. Morzone on court etiquette. I didn't think that was quite appropriate at this stage.
Yeah, no, I understand. Oh, look, I almost didn't put that on. That's Judge Morzone now. But Judge Morzone is a judge in the Planning and Environment Court, and it probably shouldn't have put it on this course. I certainly do for the law students that I teach. But yeah, I understand. It probably was a bit much, John, so my apologies there.
I only got about 30 seconds into it and thought, this can wait until I'm in trouble with the law.
Yep, I agree. And look, I mentioned that there's some that you can probably look at if you've got time. That might be one of them. The other one is there's one with Rod Litster, QC, and that deals with a case that I used to prescribe as a case for review. So it's relevant in the sense that you get to hear from a QC who was involved in the case that was under discussion at the time, but it's not directly relevant to the case that you're reviewing this time.
One quick question. On the assignment, even in Part A, Assessment 1, Part A, the Brandbid case, which seems such a fairly straightforward case, and yet it requires the most words in the assignment. Yeah,
and look, my general philosophy on that is if you can answer a question efficiently, do so. But generally speaking, I would always get to about at least 80% of the word count, even if that means adding in some supplementary material that's not directly relevant, because there's always a few little bonus marks that you can pick up. So don't exceed word counts, or in my case, don't exceed them by much, but don't be so efficient that you miss out on opportunity to tell me something that might be interesting, even though it's not directly on point. Does that make sense? That's just, I guess, some assessment technique. I won't use the word padding, but I want, good information.
Waffle.
No, not waffle. No, I'm not using waffle or not using padding. Words we don't use. All right. Well, I'd better go. Thank you very much for your patience. Suzanne, thanks for bearing with us and getting that microphone working. Jace, John, thank you for joining us. And please get on UCrew and say to your colleagues, get online on a Thursday night. Where else would you want to be? Okay. All the best. See you then.